but you're going nowhere. Don't blame me for what you've done, 'cause I know that you were having fun.
Welcome to the Clarified Realty Podcast, exposing the real estate secrets your agent doesn't want you to know. Here's your host, Tom Clary.
Well, don't you just walk away. That's when I'll say.
Hi, everybody. Welcome to the Clarified Realty Podcast. My name is Tom Clary, and I'm your host. I'm a licensed real estate agent here in the beautiful state of California, Los Angeles to be exact. Our good friend Ron Bruno will not be joining us today. He had a prior commitment he needed to attend to, but what the heck, life goes on. He will be joining us soon enough again, but he does send his regards to everyone, though. But I'm really excited about today's guest. As most real estate agents will tell you, most people move or buy a property when they are going through some sort of transition. Maybe the kids are growing up and going to college, so it's time to downsize, or maybe, God forbid, there's some sort of death in the family. These are the things that create circumstances where real estate needs to be bought or sold. Well, one of the most impactful and unfortunately the most prevalent is divorce. Today, we're talking with Doug Wolf. Doug is a family law attorney in Woodland Hills, California. He's been practicing for almost 40 years. Wow, 40 years, he nods, yes. He is a specialty with domestic violence and sexual abuse cases, so the real worst of the worst when it comes to this situation. So, Doug, it's an honor to have you here. I really appreciate you being here today.
Thank you. I really appreciate being here. Thank you for the opportunity.
So, as we do with all of our guests the first time that they're here, we always ask them the same exact question. Where the hell have you been, and how the hell did you get here?
Oh, we don't have enough time to go through all that. This is definitely has been a circuitous route to be able to get here.
Right.
I mean, after all, how many kids at the age of 7 years old grow up and say, "Oh, I want to be a divorce attorney when I grow up"?
No, wait a minute. Now, wait a minute. You're saying that when you were 7 years old? Seriously?
No. I'm saying that's what they don't do.
Oh, got it. Okay.
Absolutely do not.
I was like saying, if you're like on the schoolyard, you're like saying, and like two like boys and girls are like, it's time for us to just break up, and you're like, well,
Yeah.
you should have a chat with Doug.
Yeah. No, it didn't work that way.
Yeah. Right.
I always kind of knew that I wanted to be an attorney.
Okay.
And so I actually went to college at UC Santa Barbara.
Okay.
Spent a couple of years there. One of the few people in the world who actually didn't like UC Santa Barbara.
And my Lord. Well, because I go there occasionally with my wife and all that. We go up there and have like a lovely, Saturday on State Street and all that. It's like, how does anybody get any work done around this town? Because it's so beautiful. But
absolutely gorgeous city.
Yeah.
Unfortunately, Isla Vista was not one of the most pleasant places to live.
And
so as a result, I decided to transfer out of Santa Barbara, and I graduated from UC Davis.
Right.
A very proud Aggie, and went to law school at Southwestern.
Okay.
And
my wife also went there. My wife is a estate attorney. She does wills and trusts.
Oh,
so,
very good.
Yeah.
So was at Southwestern, and I actually did not go to law school, though, in order to become a practicing attorney.
Oh, really?
I had gone to law school because I was very interested in politics, and thought that I was going to become a campaign manager or a policy wonk or one of those kind of people.
Get out of here, really?
Yeah.
So you were maybe going to be a politician?
Yeah, absolutely.
Wow.
So
did you ever run for office?
I did. I actually ran for office in, I think it was 1985, either 85 or 87.
Okay.
I ran for the local school board, LA School Board.
Oh, got it. Great.
So, and unfortunately learned the hard lessons of politics, which is, you need money.
It's all about the Benjamins.
Yeah. I had the endorsement from the LA Times, but unfortunately just couldn't do anything with it.
Wow. Interesting.
So yeah.
But then, so it's this kind of circuitous kind of route to being an attorney. Then.
Absolutely.
Yeah.
So I, when I got out of law school and got sworn in, looked around the room and go, well, maybe I can try this for a couple of years.
Yeah.
I mean, it'll look good on my resume.
Sure.
And here we are 40 years later.
Yeah. Somehow you got kind of stuck.
Yeah.
Wow.
But I didn't necessarily get stuck because I enjoy doing what I do.
Right.
And I actually fell into the area of family law again.
I was about to ask. So, how did you get what did you start with? What kind of specialty did you start with, or did you not have a specialty?
Well, basically, I worked for a two-man partnership when I first got out of law school.
Okay.
6 months out of law school, I made the decision. It's always great to be young. Made the decision to hang up my own shingle, and I went out on my own. And at that point, I was doing quite a bit of business type work, representing franchise type of organizations.
Oh, interesting.
But then in January of 1983, my sister-in-law was murdered.
Oh, sorry to hear that.
And as a result of that, my practice took a whole different turn.
Oh, wow.
I got very much involved with other victims' rights groups.
Right.
And as a result of the lobbying, so to speak, that I was doing with other groups, I was networking out. They learned about me, and they asked me if I would be interested in getting involved in domestic violence and sexual abuse cases, representing victims only.
Wow.
And so as a result, I did that.
Right.
And my practice evolved into a full family law practice, which it's been now for, almost 40 years.
Well, it's so fascinating that you could see that direct line, I think, from what was a horrible experience in your life to basically creating something positive out of it. It would seem like you're now having, your career, which is you're helping people who are going through these kind of situations where domestic violence and, violence is an issue. And do you feel like you're really kind of helping people in that way?
Definitely.
I assume.
I don't think I could be practicing in any other area, to be honest with you.
Right.
I think this is an area of the law where you can have an impact on people's lives.
Right.
And you have that ability to be able to empathize with them, but at the same time, to be able to be, an advocate for them where a lot of times those type of individuals are not provided the advocacy that they need.
Right. It's fascinating because I think that, as this is a real estate podcast, right? And of course, the separation of property is an important part of this whole process. But, what it really always comes down to, even what I do, is about reducing conflict, right? About trying to take conflict out of two people trying to come to an agreement, right? That's my job, and I think it's your job, certainly, right?
Absolutely.
And when you add this extra aspect of there being physical violence, of there being some sort of threat, and we're talking about an actual threat. We're not even just talking about like some sort of, I feel threatened kind of thing. It's like, no, this guy is actually, possibly going to be waiting for me outside kind of thing. That takes on such a completely different complication.
Oh, there's no question. The dynamics that you're dealing with in those kinds of cases is far different than what I refer to as like the bread and butter, type of a divorce, the normal divorce.
Right.
The idea is to try to figure out how you can reduce that conflict to such a point that you can work with the people to be able to resolve whatever difference they have. Unfortunately, in most of those cases, the domestic violence cases, the sexual abuse cases, it's almost impossible to be able to work those things out without the assistance of the court.
Right.
Whereas when you don't have those dynamics in play, you then stand a much better chance of being able to work with people and be able to avoid the court intervention.
Right. Right. So I think that's kind of a good starting point in terms of this conversation, I think, about talking about, let's say I'm somehow abused by my spouse, right? Or, where a woman is being abused by her spouse. And there's the first stage of everything is just, well, not even just thinking about, God, I want to keep the house. I want the kids to have the, house near the school and where they're going and all that kind of thing. I just need this man to be out. I need this person to be out of our house. What are those kind of steps that you would be advising them to be taking along that way, especially if there's a violence as an issue?
Well, let's make one correction first, and that is, it's not just always women who are going to be the victims in those kinds of situations.
Of course.
I actually have, represented some men who have been victims in those kinds of cases.
Right.
And so you're dealing with, somebody who's an aggressor. How do you get that aggressor out of the house? And actually, the laws are pretty good in terms of being able to protect individuals. We have, a pretty good set of rules and procedures that we can follow in order to be able to get what we would refer to as a kick-out order.
Okay.
The most obvious type of situation would be if there's that actual evidence of violence.
Right.
Somebody has been hit. The courts are going to grant a restraining order in those type of cases almost every time that would happen.
What would be some good ways of documenting that?
Well, obviously pictures.
Okay.
If somebody has been hit, and it's always important to point out too that when you're in that kind of a relationship, you want to be able to take action immediately. You don't want to wait to have that violence escalate, which is what ends up happening most of the time.
It doesn't
in
get
domestic-
better.
No,
Everybody
absolutely.
always thinks, oh, he's going to change.
No, not only does it not get better, it gets worse.
Yeah.
So as a result, when you're dealing with those kinds of situations, you want to be able to take action immediately. In terms of the documentation, pictures are always the best way to go. I always recommend to clients, when they're in those when something like that happens, that their first call is to the police, and then the second call is to the attorney.
Got it.
So that way
It's kind of
get
triage.
the protection. Absolutely. You get the protection that you need first.
Right.
That's always, the most important thing.
Right.
And then you can always deal with the ramifications of that.
Got it.
So, but when something happens, you apply for a restraining order.
Right.
Hopefully you get that restraining order, and the restraining order, part of the restraining order would be that there would be a kick-out order, that the individual is being told that they must move out of the residence. Most times the courts are going to grant those kinds of orders, assuming that you have made that showing that there is a need for it.
Right.
Being hit, being abused, those are the kinds of things that are going to demonstrate to the court that this must take place. If you don't have the physical evidence, if it's strictly verbal, it becomes a much more difficult situation for a judge to determine whether that individual should be thrown out of the house or not without a hearing taking place, which is normally what would happen when the restraining orders are granted. So they're always being careful in order to determine whether there's enough evidence there to make that happen.
Right.
Even if the restraining order would not be granted at that hearing, there's always a second shot at it. The court will then set it for a hearing where both sides will then be present. Both sides will have an opportunity to be able to present that evidence, and then the court can make a determination at that time.
Got it. So let's say that you do have that kick-out order, okay? And so if they are, I guess that means that it's like literally they can't be near the house, correct? I mean, is there a certain space like they have to keep, like a buffer of some sort?
Again, depending upon how the orders are drafted, the normal order will say that the individual will have a certain amount of time to remove their
Well, that's what I was
personal
going to,
belongings.
is like some sort of personal property has got to probably be in that house. How do they get it out? What's the...
Right. Now, they're not allowed to take everything out of the house, but they're
okay.
allowed to take, for example, their clothes, toiletries, things that they're going to need until the next hearing. Because even when a restraining order is granted at that stage without notice, so to speak, there's then going to be a follow-up hearing that's going to take place in roughly 20 to 25 days. And at that point, both sides are going to be present in court with or without their attorneys if they're being represented or not. And both sides are going to have an opportunity to present their evidence to the judge. And the judge will then determine at that point whether the restraining order remains in effect or not. So that's kind of how the procedure would work.
Got it. So let's take it down further on down. So not needless to say, something is probably going to be a contentious divorce. I mean, usually, I mean, if it's starting with violence, it probably doesn't get like nice.
No.
Generally speaking, people are not like, sending roses back and forth. This is something where it's going to be a fight the entire way.
Correct. And
Go
people
ahead.
always make it difficult.
Yeah. So, Mike, I guess then how do you deal with a circumstance like that in terms of the division of the house? How, do you, well, let's start with, let's say that they come to an agreement like, okay, some miracle happens and they both agree, all right, let's sell the house, right? So go take that step. What would be the circumstance there?
So when you get into a situation like that, first of all, you're going to want to have an order of the court that will lay out exactly how that sale is going to take place. So
what would that look like?
So you would enter into, it could be one of two things. If it was going to be an agreement of the parties, then you're going to enter into what's called a stipulation and an order. Stipulation just being a fancy word for an agreement, and the order would be that which would be signed by a judge in order to be able to enforce it. And that stipulation and order would lay out a variety of terms. You would start with, how do you pick the realtor? Who goes about doing that?
Yeah, I mean, that's such an interesting, I've been through this circumstance where it's literally two people wanting two different people, right? So you have to come to this decision of like, well, listen, what's best for you guys, right?
And there's all different ways that you can go about that selection process. Sometimes maybe one party is going to be the individual who's going to select it.
Yeah.
That doesn't happen most of the time because, again, if you have one party selecting the realtor, then you're going to have a situation where the other party is not going to trust the realtor.
Right.
So that rarely
Tell
happens.
me about it.
More common will be that one party will lay out 3 names.
Yeah.
And the other party then will select one of them. That's one way. Another way might be that both parties are going to select 1 name, 2 names, and then they will meet and confer and try to do it that way. The fail-safe on it is if they're unable to do it, then it falls right back to the judge. Both sides will present 1 name, and the judge is the one who ends up then picking who it's going to be.
Right.
So that's the first step. How do you pick the realtor?
And I'll say that the process that you said about each of them, because what I had heard was before, and what I think is a great process is they pick 2. That means there's got to be an overlap of 1, right? So
Not necessarily.
Well,
with all the realtors
somehow.
that are out there?
Well, no, I'm saying no. You pick 3.
Uh-huh. Oh, I see what
Each
you're saying.
pick. There's 3. You say here's a pool of 3.
Mhm.
You pick 2 and you pick 2, and generally there's an overlap.
Correct.
And so that's kind of, by no means is that going to be the fail, like not the fail safe, but the the silver bullet here. But it's a good process for possibly narrowing it down,
Right.
where they can both be on the same page with some person.
And one would hope that this would be the easiest decision that they have to make, but it never turns out to be that way.
Never. Well, it's also because it's their largest asset usually, right? And that's where they want to make sure that they have the best net. Or there's sometimes counter ideas like, I want to buy the house, or why don't I get it and you go pound sand. You know what I mean? That's another question. While I'm here. Is there ever circumstances where people kind of just lose their rights to the house or anything like that, or is it?
When you say lose,
let's say if I'm kind of, it's a leading question because I kind of know the answer, but the idea of that there's 2 people that they're on the deed, it's their house. Are there any kind of circumstances where one person loses their rights to it? No,
I mean, there could potentially be, but it would be so rare. I mean, you could get into a situation, let's assume one of the parties put up almost all of the money in order to be able to purchase the house.
Okay.
And even though both of their names are on the house, when the house is ultimately sold, the individual who advanced that money under general circumstances is going to get that money back
Oh,
first.
really? Interesting.
So if you're talking about a situation where the equity were to equal the amount of money that was put in as the down payment, then yes, the other individual could walk away and get absolutely nothing from the house.
So then it would be, but how does that deal with this, it being a separate property versus, you know what I'm talking about, joint,
Right. The house itself could be considered community property still because both names are on it. And it gets a little bit more technical than that. But from a general sense, the house could still be considered community property. The idea, though, that one party came in with a down payment, that down payment could be separate property. So as a result, you have a reimbursement of separate property that has to be made first.
Got it.
Before the community property could actually be divided.
Got it. So if they brought their own separate money into the whole deal.
Correct. So
Got
just
it.
hypothetically, if let's say you had a house that had $200,000 in equity in it,
Right.
and one party had a home before that they had sold, and they took that equity, which was $200,000,
Right.
and used it as a down payment on this house.
Yeah.
House gets sold. There's $200,000 in equity, but there's a $200,000 down payment that must be reimbursed first.
Right.
So you take that first, then you have nothing left over for equity. So at that point, there's nothing else to divide.
Interesting. So, okay, well, let's go back to the process of it being an understanding where both people are okay. We're both okay. Now we've both picked either we're both going with the same realtor. Okay, so we're trying. This is like the right down the middle, slam dunk thing, right? Where you pray for when you go to bed at night. You go, please, dear Lord, please let every client be this way, right? What do you tell your clients to be looking out for during that process, even if it's that kind of, straightforward, no curveballs?
Well, first of all, I like to be involved in the process all the way through. So if the client is going to be signing documents, I like to be able to review those documents. So when you have the deposit receipt, for example, I want to be able to take a look at that deposit receipt before they sign it in order to be able to know that The price is what they want it to be. The commissions are what they want it to be. The disclosures are being done in an appropriate fashion, so that way they're not going to get caught later on with a "oops, we forgot to disclose something on it." So we want all of those things to be done. I want to be able to take a look at the escrow documents once the house is actually that there's an offer.
Because I would think even if something goes sideways in 10 years or whatever, blah blah blah, you now have to get back together with that other person in order to work it out, correct?
I may or may not. Again, it depends. If it's no longer a quote-unquote family law matter, but it's more so a more specialized real estate issue, then it's going. For me personally, it's going to go to a different attorney. Now, there are some attorneys who obviously they practice in multiple areas, and so they will go ahead and they'll handle it that way. But
they don't have to get together with their spouse in order to resolve it.
Not necessarily. Again, it depends upon what the issues are that are being raised on it at that point in time. So I like to see the documents. Another issue though that comes up almost immediately is how much are we going to sell the house for? Some people have a very, very inflated value of what it's going to be.
Absolutely.
Or maybe they truly don't want to sell the house. And so they're going to set it up at a value that is going to be so ridiculous that everybody knows that it's not going to sell. So again, another one of the things that you may want to put into the stipulation in order is that if the parties can't reach an agreement as to what the value of it is going to be, then that value is going to be deferred to the broker or the real estate agent. They would be the ones who are going to make that decision.
Got it. Well, and you would think that there's, far be it from me, since I sort of have a slant this way, but I kind of know what I'm doing. You know what I mean? So wouldn't you be trusting the professional anyway to be coming up with that number? I mean, I know that nobody's going to trust me. I've heard all the people saying, well, hold on a second, whose interests are you're looking out for and all that kind of thing. But at the end of the day, we know the market probably a lot better than either of the parties.
But you're dealing with people who are being very, very emotional at this point in time.
Correct.
So it doesn't necessarily mean that they're thinking rationally and that they see, that issue. Plus, what happens if you were on one spouse's list and not on the other spouse's list, and you're the one who ended up getting selected? That other spouse is never going to trust you in terms of what you're going to be recommending.
Of course. Yes, no doubt.
So there's always that kind of an issue that's going to come up. So hopefully you deal with the selection of the broker, the selection of the price that's going to go into it. And then you also want to be able to include a provision in that stipulation and order that's going to say that the court is going to reserve jurisdiction over the terms of the sale, the manner in which the sale takes place, and the distribution of the proceeds. What that does is it allows, in the event that there's any kind of dispute as you're continuing in this process, that the court is continuing to be involved and that they're
monitoring it, basically.
Correct.
Because I'll say in circumstances I've seen and been involved with where you see, you're as an agent, you're out there charging forward, right? We're marketing the hell out of the house. We're trying to make sure that, as many butts get in the seat, basically to see this beautiful home or whatever kind of thing. And you see these little sabotages happening here and there. And it gets to the point sometimes where you kind of have to go, okay, flag on the play. We need to do something about this. And that's why you're saying that the court needs to still kind of be checking in on things.
Correct. And another thing that the people need to be aware of when they're selecting that broker, just like in any profession, we all have our strengths and we all have our weaknesses. And there are plenty of real estate agents out there who may not necessarily understand all of the dynamics of going through a divorce. And they're entering into this transaction blindly, just figuring this is going to be the same as any other transaction we ever do.
Well, look, and by the way, this is a little sidebar here. True story. It's, I think, one in every, what is it? I think there's 1 in every 50 people or something like that is a real estate agent here in California.
No kidding.
It's insane how many real estate agents there are. Like if you walk into a restaurant, at least one of the people that are sitting in one of those tables is a real estate agent.
Oh my God.
So the competition is crazy, but there's constantly an influx of new people coming in, and they haven't experienced what it's like to actually go through a transaction, let alone something that can be such a chaotic, crazy thing where emotions are at red, hitting the top of the gauge, and people are trying to kill the deal sometimes, and somehow finding a way to get from A to B.
Right.
And so what would you be telling your clients to be looking for in an agent?
Well, I would want them to look for a broker who actually has experience in dealing with divorces. That they've gone through this before, that this isn't the first time that they've worked with it. And quite honestly, I wouldn't want them utilizing somebody who doesn't have a lot of experience in having dealt with divorced couples before.
Right.
Because the landmines are all over the place.
Yes.
I mean, I remember a divorce I was involved in probably about 5 or 6 years ago, in which literally both sides would not clean up the house.
Yeah. Mm-hmm.
Neither side was going to remove the last bit of stuff that had to be taken out of the house. And the realtor ultimately had to hire a crew to bring in a crew to do it.
Right.
Now, somebody who's not experienced and doesn't know is going to freak at that last moment when everything's supposed to close and you're supposed to turn the house over.
Oh, yeah.
And it's not ready to be done.
Yeah.
So I think it's really, really important that when people are interviewing the real estate agent, that they bring in somebody who has experience.
Yeah.
And I'm aware of the fact that there are designations, in terms of people who have specialized in divorce, or they've gone through that type of training in order to be able to understand the process better. And it's not only just to be able to understand the process in terms of how a divorce works, but it's to understand the emotional dynamics.
I think that, and by the way, I think psychologically, that's almost as important. I think because. Like this is, I'm just thinking of a recent one of an agent, not me, but another agent, and got down to the point where it was a divorce, and it was time for inspections, and all of a sudden the wife shut down, like literally, it's like, nope, I'm not, I'm too busy, I can't do it, I can't, I've got these things to do, and I got that kind of do, and so it took literally, kind of a bit of strong arming on one side to basically say, hey, listen. You're in the middle of a transaction. People have to be able to get in and take a look at the house and do their inspections. But also, it took a little bit of time to just sit there with that client and listen. And basically, she needed to vent. She felt like she wasn't being listened to. She didn't feel like, she thought that she'd been steamrolled by other men and things like that. And there was a male agent. And so it was the psychological dynamic that if he was, thank God, very experienced. He's a very experienced agent. But if most would just kind of collapse and not be able to deal with this and not understand that what we're dealing with primarily is almost a hostage negotiation. Really.
Oh, absolutely. The emotion play every part of it. I mean, I can share with you, one that I was just involved in not too long ago, in which a house was being sold. The husband did not want this house to be sold. He wanted to keep it.
Right.
And he was living out of the house at this point, but he wanted to be able to, buy the house from the wife.
Right.
The wife, on the other hand, wasn't willing to allow him to buy it because by doing so, it was an admission that the kids were going to be able to stay in his house now rather than be living with her, even though it was a split custody type of arrangement. But she didn't want to be the kind of a situation where the kids were going to be in the house with one parent, but they weren't going to be in that house with the other parent.
Right.
So luckily in this case, they both agreed on a broker. They both agreed on the listing. And then all of a sudden, they got a quick offer on it in order for it to be purchased.
Yeah.
And then in this particular case, the husband went into that shutdown mode. It was like, oh, no.
Yeah.
We didn't set the price right. It should have been higher.
Right.
How come this is going so quickly?
Mm-hmm.
Then it went to inspection. And he took a position of saying, well, if they come back with anything that needs to be done, that's it. The deal is off. I'm not going forward with this deal. So it's the same kind of situation that you're talking about. The broker, who happened to have been a very, very experienced broker working with divorced couples, had to do the same kind of thing. She had to let him vent. She had to, had to take him through that process. Say, wait. Let's not get, so excited. Yeah. Let's wait to see what they come back with. Maybe they're not going to come back with anything that'll be so significant. And sure enough, that's exactly what happened in this case. Yeah. It was handled very, very appropriately, and they were able to save that sale.
Right.
But those emotions can absolutely, submerge the deal that quickly.
Absolutely. So let's take a circumstance where let's say that the wife wants to move out of the house, the husband wants to stay, like you just said, but they're able to come to some sort of agreement that they will buy it from each other. What is that process like?
Actually, if you don't mind, let me go back because there was one other point in the stipulation order that wasn't covered. And that was, okay, so if the house gets sold, what do you do with the money?
Yeah, of course.
Let's
right.
assume that the divorce is still fairly early, and there's still
Oh,
a
and
lot
it's
of
not
other
completed,
issues.
right?
Right.
Yeah.
There may be other issues that still need to be done.
Yeah.
So what you can do in that kind of a situation is that you can advance a certain amount of money to each of the parties, because obviously they need to move. So
Right.
they need some amount of cash in order to be able to allow that happen. And then what you can do is you can tie up the rest of the money. Some people will go ahead and they'll tie it up by just leaving it at escrow. I'm not a real fan of that. My idea is to get it out of the escrow and do something else.
Right.
Another way to go about doing it is to allow either of the attorneys to deposit into their client's trust account.
Okay.
Now, attorneys have those kinds of mechanisms, and we're obligated by state bar rules that when it's money that is in a client's trust account, it's designated. It cannot be used by the attorney.
Yep.
It's not going to somehow just vanish. So
you can't even borrow it.
That's exactly right. It's the quickest way to be able to get disbarred.
Oh yeah.
So the money can sit in one of the attorney's client's trust account,
Mm-hmm.
or another way of being able to do it, although it is not as commonly used anymore because the banks are not as willing partners in doing this, and that is you could literally go ahead and set up a 2-signature account in the bank, deposit the money in there, and then any withdrawals would require 2 signatures of both parties in order to do that. But as I said, we have found that it's becoming more and more difficult to find a bank that's willing to go down that road. And
So what is their liability on that?
What, as far as the...
Yeah, why would they be...
I've never been able to get a straight answer in terms of why they're not willing to do it.
Right,
It's
we just don't want to do
They
it.
just don't want to do it. So, so as I said, it doesn't happen that often to go that route. Normally, it's going to go into one of the attorneys, and so this way, then the money sits there until you get a court order. So it's not even... You can't even, for the most part, do it just based upon an agreement of the parties, because if it's a court order that put the money into the account to begin with, you need a court order for it to come out.
Right.
I have a situation, for example, where money went into my trust account, and then I was no longer representing the client.
Yeah. What do you do in that? What do you do?
At that point, I still can't remove the money from my trust account without a court order telling me where I'm supposed to send.
So
that
basically,
money.
you're getting directions from a judge to basically say, oh, okay, now you can take it out and do something.
Correct.
With it. So then
Now,
you can go and say, well, the judge told me that I could do it,
right,
or whatever.
And it can be done based upon the agreement of the parties, so long as the judge signs off on it as well.
Okay. Got it.
Okay. So that's the other major point, though, that needs to be put into the agreement, so that way they know what to do with that money.
Because you don't even think about it. I mean, after the whole process of selling a house, you think, okay, escrow closes, money goes to you, money goes to you. No, because if the divorce is still not final and agreements have not been completely made and all that, you still have something in flux.
Right.
So
because some of that the rest of that money may not be divided 50-50 between the parties. There may be other money that's owed to one party.
Right.
And so as a result, you want to keep that money in place so that you can do the accounting that needs to be done, take care of all of the assets, and then at that point, then you can go ahead and divide the money accordingly.
Got it. Do you, in terms of still staying on, let's say a cooperative divorce going through where, everybody's kind of roughly on the same page. They're never completely on the same page, but roughly. And they're selling it with a broker they both agree with. What kind of advice do you give in terms of the process of it, in terms of, even just the marketing of it, do you ever kind of like put your 2 cents in, or in terms of like, should I put money into fixing it up? Should I, because sometimes to get the best net for a house, you need to do some cleaning, you need to do some, maybe a small little thing here and there.
I generally take the position of deferring to the agent.
You do.
My feeling is that's their job. Okay. They know what's going to sell a house and what's not going to sell a house.
Got it.
I mean, I know the general kinds of things, like, if a client's going to come to me and say, well, we're thinking of selling our house and, we're going to sell it like in September, October. I may say to the client at that point, well, is there any possibility you might be able to wait until the spring to be able to, sell it then?
Right.
Because historically, you're going to get a better price for it at that point. I might do something like that. Or if the parties are looking at it and they're saying, well, we want to put in a brand new kitchen before we go ahead and sell it, I may talk to them and say, well...
You think you were fighting before.
Right, exactly.
So you guys want to fight about what color the kitchen's going to be? Yeah, right.
So I might put in my 2 cents on something like that.
Right.
But most of the time, hopefully they have secured a very experienced real estate agent,
Right.
somebody who knows the market,
So
somebody
you
who
do
knows what's
defer
going to work.
basically to
Right.
it.
And I'll let them make the decisions. Now,
Got it.
my client may come to me and ask me for my advice. And as I said, depending upon what it is that they're asking, I may or may not put in my 2 cents.
Got it. So, okay. So jumping back to where we kind of started before, where we were talking about, okay, I've made an agreement to go ahead and sell this house to my wife or whatever. She's going to go ahead. Does a real estate agent, do you feel a real estate agent should be involved in that transaction, or do you think that it's something that the attorneys can handle, or what are your feelings about that?
Generally, if it's going to be just from spouse to spouse, I don't necessarily feel that a real estate agent needs to get involved in that kind of situation.
Right.
We're normally creating a situation where you're going to do an interspousal transfer deed. The terms of the judgment or the court order are going to be fairly explicit in dealing with it. So for the most part, I don't think that's necessary. Where the issues come up, and it's not necessarily because of the need of a real estate agent being the case, but let's assume you have one party buying out the other party, but you still have a loan on that property that's in both of the parties' names.
Right.
You have some difficulty that you got to deal with, because the party that is selling out and is no longer going to have an interest in the home still has their name on a loan.
Yeah.
And if they go out and they now want to go buy a house somewhere else, all of a sudden when their credit report is coming up, they've got this other loan there, and that's going to make it more difficult for them to get the financing that they need.
Right.
So it becomes necessary for the attorneys, when drafting up that order, to make sure that there is going to be no liability for the party who is selling their interest in the home.
Right.
There has to be a provision that's put in there that deals with the refinancing the property within a certain period of time, or if they're unable to refinance that property, then the property needs to be sold outright,
Right.
with the party that bought out the other one still being able to retain all the proceeds for it, though.
Right.
So those are the kinds of details that you still have to be careful about.
Right. And this is something that I'm, wholeheartedly on your side on this, because I mean, actually I think it's a sign of a very good agent, because they will step back. They'll know that it's like, look, there's no reason for me to be here. You know what I mean? You should be talking about, because I've had circumstances where I've had, a party kind of come to me and say, okay, I want to try and do a deal between me and my, it's like, look, you guys should just handle it together. You should not be, this is not, and there are folks who are out there, the 1 in 50, who are just trying to eat, you know what I mean? And they're doing things where they really don't need to get their noses in. And I think that's separate. If you're just trying to do a transition from you to your spouse or your former spouse, if you guys can work it out amicably, I think that's, more power to you.
As a more general statement, just in family law as a whole, the idea is for the people to work it out.
Yeah.
I talk to people all the time, and I always make it clear. Do you want to be the one who's going to be making decisions in your own life, or do you want to defer that decision-making power to somebody else who doesn't know you,
right,
has no clue what you or your spouse may want to do? Now, the intelligent person says, well, of course, I want to make my own decisions. Right. The ones who don't, you have to say,
I'm good.
Go have fun.
Please take it over.
But, ideally, that's what they should be doing. And if they're going to go down that road, then really they should be looking at mediation or collaborative services.
Well, talk to me, because we before we started, you kind of mentioned how you really kind of lean this way in terms of conflict resolution, and I'd love to hear more about, do you when someone walks into your office, do you maybe start that road, like say, hey, let's see if we can do it that way? Like, is that how the conversation starts?
We actually start that road on the phone call before they're ever in the office, because part of the problem is if somebody's coming in to see me for mediation services, I need to know that up front, because my responsibilities as a mediator are different than my responsibilities as an attorney. And if somebody comes in and they're starting to tell me their life story, and then they go ahead and, oh, by the way, we want you to be our mediator, Well, I can't at that point because I already have received a lot of confidential information.
And you're already kind of, you can use that on one side.
Correct. So I have to know what hat I'm wearing before the client ever comes in the office. So when somebody calls my office and they indicate what it is that they're calling for, my staff has been trained to be able to say to them, okay, are you coming in for mediation, or are you coming in just to see Mr. Wolf as an attorney? What is it that you want to do? And that's how we can differentiate it. So that has to be done up front.
Right.
Once we know, though, if I have a client who comes into my office and they're coming in theoretically to retain me as an attorney, I will still have that discussion with them, though, about mediation and collaborative. I can't be the mediator.
You then have to refer it out to somebody else.
And I make that very clear that I can act as the consulting attorney for them, still providing them with advice, still doing all the things that you would normally do as an attorney. But as far as the actual mediator, the mediator would have to be somebody else who would do that.
Got it.
The advantage of mediation, the best advantage of mediation is that idea of control.
Right.
You're controlling your life. You're making decisions that are going to define what your future is going to be.
So instead of getting a judge or the courts involved, it's something you guys are deciding between the two of you.
Absolutely. And for the most part, not in every occasion, but for the most part, it's going to be a lot cheaper going through a mediation than it will be going to court. If you're dealing with a skilled mediator, they're going to be able to control the process. They're not making decisions for the people. They're not even advising those people who are participating in the mediation as to what they should do. That would be inappropriate for a mediator to do.
Right.
What they're doing, though, is they're creating a safe environment that allows the individuals to talk about the issues, sometimes yell about the issues.
Do you have soundproof offices, by the way, Doug?
We hope. But it gives them the opportunity to be able to talk about these things in a safe environment, and then hopefully resolve them.
Right.
I always talk about, too, one of the major differences between going to court and going a mediator. When you go to court, you're not talking to each other. You're talking to the judge.
Right.
In mediation, you're talking to each other. Right. You're not talking to the mediator. You're talking to each other. So those are really the advantages of why people should go through mediation rather than going to court.
Right.
There's also, though, the avenue of going through what's called collaborative services, which is not as well known.
Now, what is that?
So collaborative services have been around for a very long time. It originated by a group of people out of Minnesota. And the collaborative process is a hybrid between having attorney representation but utilizing mediation type methodology.
Oh, interesting.
The clients each are being represented by an attorney, hopefully who have been trained and certified in the collaborative process. Okay. So it's not just some attorney who says, oh, I know how to do it.
Oh, I can do that.
Yeah. But it's that they've actually gone
I've
through
done it
that
twice.
process. Right. And then the other key element in the collaborative process is that they will sign an agreement that says, under no circumstances are we going to go to court. Court is not an option.
Oh, so never an option.
Never an option. Now,
oh, interesting.
If it is chosen as an option, everybody who's involved in that case, the attorneys, the real estate agents, the financial advisors, the child custody coaches, the mental health professionals, whoever it is that's been brought in to handle that case, they all have to step aside.
Oh, wow.
They cannot provide services to those individuals because it was done under the umbrella of a collaborative process.
Oh, so we were all going to try and get along, folks, and then one of you guys decided to take your ball and go home. We're now stepping back because we have information from both people and we have things that could help that person more than that person, whatever. We're going to step back. You lose that.
It's for that reason, but it's also Damocles' sword. It's the sword that's hanging over their head that says, if you choose to leave this process, you're going to have to start all over again. You'll have to get another attorney and pay a new deposit to that attorney and have that attorney
it could be
come up to
expensive.
speed. It gets very expensive.
Interesting.
And I actually was not a real proponent of the collaborative process when it first started, simply because of that anti-consumer type of provision in there. You have a client who comes in, they've spent, let's say, $10,000 into the process, and now all of a sudden they're being told, sorry, can't do anything with it.
I could see how it would be more impactful to someone who is scraping together pennies in order to do it against like a big corporation. I can see why the corporation would want to do it, because for them it's kind of pocket change to get it started again if they wanted to.
Right.
But, it does kind of put a balance of power off kilter, doesn't it?
Correct.
Yeah.
So, but I'm definitely a proponent of collaborative now, and have gone through the training.
What changed your mind?
Well, California adopted it as an option, and they set up rules and procedures for it. And being a family law attorney, I want to be able to have the opportunity to provide multi-services to my clients.
Right.
So if somebody comes in and they want the collaborative process, then I want to be able to be in that position.
Are there circumstances where it works better than others?
Oh, absolutely. I mean, clearly. So let's go back to mediation for a second, because the stereotype example that I utilize for mediation that will never work is a kind of a situation, and I'm using the sexes in a stereotypical manner. It doesn't necessarily mean that that's the way it is. It can go either way.
Right.
But, couple been married for 25 years. Husband's been the breadwinner. The wife has been basically a homemaker. And the husband comes home one day and he says, "Sweetheart, this marriage just ain't working for me anymore. And you know what? I think we need to get a divorce." But, we have worked so hard to accumulating the assets that we have. I just don't think that we should both go get attorneys. Why don't we go down to the mediator? And I know this mediator who would be really, really helpful for us. The problem with this scenario is that the wife has never taken care of any of the finances.
Okay.
She doesn't know the extent of anything that has existed.
So at the start, she's kind of at a disadvantage.
You don't have an equal playing field. And that's the key. For mediation to work, there must be that equal playing field.
An even knowledge, basically.
Correct. In a collaborative process, it's not as important, because you have two attorneys who are representing
other folks who
party,
are talking about it.
and everybody's going to be talking about the discovery and the accumulation of the documents and everything.
Right.
But if you have the husband and wife who come in to meet the mediator, and the husband goes, "This is what we've got,"
right,
and you turn to the wife and say, "Is that true?" And she goes, "I don't know. If that's what he says," it's not going to work in a mediation.
Interesting. Got it. So, okay. Well, then, I guess we're going to be wrapping up here in just a little bit, but one of the last things that I wanted to kind of bring up, and let's say, because my wife is a wills and trust attorney, and I kind of have this kind of background knowledge of all this stuff. But what's fascinating is, so let's say that a couple has a trust, or that kind of, estate planning document in place, or whatever it is, right? How do you advise them in terms of, because real estate is the biggest part of that usually, about how that house is going to be transferred after one of them goes and all that. But all of a sudden now, when there's a divorce, that throws all sorts of things into disarray. So how do you advise clients when it comes to, that kind of stuff, like estate planning and trust?
So there's a couple of things. First of all, when a divorce is filed, there are automatic temporary restraining orders that go into effect. And one of the restraining orders that goes into effect is the idea that neither party can go ahead and change non-probate transfers without getting consent to the other, or getting an order of court. Now, there are ways to be able to terminate that trust, for example, during the divorce. But notice is one of the things that has to be given. You have to notify the other party and let them know that you're going to be doing that. Just like anything else, and again, we talked about this a little bit before, every attorney doesn't do everything.
Right.
So if an attorney doesn't have experience, for example, in the estate planning field,
right,
they need to refer that client then to somebody who does.
Right.
That should also be done before the divorce ever starts. Because if you're going to make a change to the estate plan,
right,
and you want to do so while the divorce is in process, that has to be done before the divorce has been filed. Again, for the reasons I said before about that automatic temporary restraining order.
Right.
Because once the automatic temporary restraining order is in,
you're stuck.
There's new rules.
Yeah.
So the ideal situation is when a client is contemplating a divorce, they go see the divorce attorney. The divorce attorney refers them to an estate planning attorney, and then they all get together in order to be able to talk about what's the best way to be able to do this. If there are changes that need to be made to the estate plan, they get made before the divorce gets filed. If they don't, as is the case in a lot of times where this happens, again, there are ways to be able to deal with it, but you're going to bring in an estate planning attorney who's going to assist you in making those changes, so that way they're being skillfully done.
Got it. Well, last kind of question I've got is, so, let's say that you're in a relationship and, you kind of see this writing on the wall. It's like, oh, it's inevitable, right? Do you do you think that which do you prefer as a family law attorney? Someone who is coming in beforehand, someone who is coming in like literally like, no, I'm doing it today. We're going to write this up today. Like, is there ability to quote unquote strategize? Is there like, does that help you out by starting the process earlier?
Definitely. But it also depends upon the circumstances of the individuals and what they have already done. A skilled family law attorney should be asking the client when they come in, have you gone for counseling? To know, have they done anything in order to be able to try to save the marriage? And it's not being because everybody is a romantic sap or anything along that line.
Yeah.
It's simply because I think sometimes, our society allows people to just jump, impulsively.
So do you counsel folks to kind of like, maybe this is something you guys want to try one more time? Like, or is that?
I won't provide the quote unquote counseling.
No.
Yeah. But yeah, definitely I do that. When they come in, I will, if it's a mediation or even when I'm, have my attorney hat on and I'm just representing one, I want to know what they've done before. And if they haven't gone for counseling, I'm going to ask. I'm going to say, what do you think? Do you think this might be a possibility? Now, in some cases, the clients are going to know. We're way beyond that. We're here. We're done. This is it.
Right.
But there are those cases, and I have had cases before where clients have literally come into my office on a mediation. They were there to get a divorce. And as we're sitting there and we're talking, and I'm going through questions with them, and I'll say, have you guys gone for counseling? Yeah, we've gone, and, we tried it, but, I don't know. Well, do you think maybe it would help? To do it. And sometimes they're going to sit there and they're going to look at each other and go,
have you seen that happen?
Maybe. Oh, absolutely. I had a case not too long ago where two people came into my office. They literally came in to get a divorce.
Wow.
And what it turned out to be was that they didn't want a divorce. They still loved each other. They just had arguments with each other over the way that each of them were spending money and what their attitudes were on financing. And so as a result, we took it a whole different way at that point. I obviously recommended the counseling.
Yeah.
But then instead of, going forward with a divorce or anything along that line, I talked to them about the possibility of a postmarital agreement, it's the opposite of a prenuptial agreement. It's an agreement that is done during the time that they're married. You divide the assets up.
Oh, interesting.
Each party has got a certain amount of assets. They can do whatever they want. We have, in essence, eliminated community property in this particular kind of a situation.
Right.
So that neither one of them has to be worried about incurring debts in the other's name or that kind of a situation, which was the biggest problem of this couple. So here they came in thinking they were going to get a divorce, walked out with the idea that they were going to go for marital counseling and we're going to get this postmarital agreement.
How fascinating.
Yeah.
And so it was kind of like a marriage saver.
Absolutely.
Wow.
And again, it's not the issue of, like in my case, of me sitting here and going, oh, well, I just love people being married, and so that's why I want them to do it. I feel there's an obligation in order to be able to look at the client who comes in and to hear what it is that they're saying and to address what their needs are. Just because the client comes in and says that they want a divorce doesn't necessarily mean that they have thought about all of the other options that may be available to them.
Right.
And it's my responsibility to put those options out there so that they can make that educated decision and determine
at
what's
the
going to be
very
best
least,
for them.
they've checked off all the boxes.
Correct.
Interesting. Great. Well, Doug, thank you so much for this conversation. It has been so fascinating. I really, really appreciate it.
Thank you. I really appreciated the opportunity.
Awesome. So why don't you go ahead and give the folks your information so that they know how to get in touch with you if, they ever need to talk to someone.
Okay, thank you. Well, my office is in Woodland Hills, located at 21300 Victory Boulevard, Suite 420 in Woodland Hills, California, 91367. Our telephone number is area code 818-888-0033. And my email address is Doug, D-O-U-G, at Wolf, W-O-L-F, familylaw.com.
Great. And do you have any kind of social stuff, anything out there? Or?
No,
No. One of those, God, you attorneys.
I'm one of the old guys.
Me and my wife, it's like Facebook for her is like, what? No, I don't have time for that.
Yeah.
Well, Doug, thank you so much. I really appreciate it.
Thank you.
All right. Well, that's about it for today. If you have any questions or comments, please don't hesitate to leave them for us on our Facebook page, facebook.com/Clarified Realty Podcast, all one word. See, we're in social. If you have any questions about real estate or you have any, if you're looking for someone to help you buy or sell a home, remember, I'm actually a licensed real estate agent. I'd love to help you out. So please email me directly at Tom@Clarified Realty or give me a call at 818-335-7662. Don't be shy, guys. Come on, give me a ring. For more exclusive bonus content and advice between episodes, please check out our website, www.clarifiedrealty.com. Also on our homepage, you'll find links to helpful buyer and seller guides that can give you some really great information for starting your home buying or home seller process, so definitely check those out. Here's something we're incredibly proud of. We have a top-ranked Alexa skill. We're actually number 4 this week, so I'm really proud of it. So search the Alexa store for the Clarified Realty Podcast, add our skill to your daily briefing, and get a dose of real estate news and tips every day of the year. That's right, every day of the year. Definitely give it a try. It's pretty cool. I'm on Snapchat, Twitter, and Instagram as well. My handle for all 3 of those are @Clarified Realty. Please leave feedback and reviews on iTunes or in the comment section on our page. Together we're stronger, folks. So if you have any questions or any ways that we can make this podcast better, please let us know. My amazing theme song, Hey Now, is from the band Wolf. That's Wolf with 2 Fs. So please go check them out and like them on SoundCloud. And just a little fine print here. My brokerage is Keller Williams Encino Sherman Oaks. I'm licensed by the California Bureau of Real Estate. My license number is 01715353. The advice I give is only for properties located in the state of California. For all other states, please contact your local real estate agent or real estate professional. Well, thanks so much for coming by, everybody. Remember, the greatest thing you can ever do is make someone feel at home. Take care. We'll see you next week.